I'm professional investigator Justin Yentis. Here we cut through the noise, dig deep, and uncover what others overlook. If you're ready to roll up your sleeves and get to the bottom of the story, you've come to the right place. Welcome to Truth Be Found. Let's get to work. Hi, everyone, and welcome back to Truth Be Found. Today, we're discussing one of the most complex and contentious topics in our justice system, and that is the death penalty. Honestly, there's way more to the story than people realize. We're going to explore what truly goes into the death penalty process, why it costs taxpayers millions more to execute someone than to keep them in prison for life, and some of the political battles taking place right now that are costing tens of millions of dollars while thwarting true justice along the way. We'll also explore some practical challenges that states face, such as how most countries refuse to sell execution drugs to the United States because of how they'll be used. It's a compelling and sobering look at a system that affects real people's lives and costs all of us as taxpayers. To help us understand all of this, I'm joined by Dale Baich, an attorney who specializes in these highly complex cases, including the final death row appeals. He's going to walk us through the timeline from sentencing to execution, explaining the costs at each step and how the legal system tries to balance justice for crime victims with the constitutional protections against cruel and unusual punishment. Dale, welcome to the show.
Thank you for inviting me, Justin, and thank you for bringing attention to the many issues that you do about that are part of the criminal legal system.
Well, I appreciate that. We started this show because we wanted to, educate the public, and in the realm of, I guess they call it true crime. There's a lot of sensational information out there. There's a lot of hypotheticals and theatrics, but I wanted folks to really have an understanding of what the justice system truly is like and what criminal investigations are from kind of an insider's perspective. And it's with folks like you coming on, it's very helpful to be able to share your knowledge with our listeners. Before we dive in, I'd like our listeners and viewers to get to know you a little bit. I've known you as a litigator in the capital punishment field for many years, and I know you've been are currently a law professor at Sandra Day O'Connor, the College of Law. Could you share a bit about your background and what drew you into this highly emotional and challenging area of law?
Sure. I grew up in Cleveland, Ohio, and I began my law practice there. And in 1988, there was a position with the State Public Defender's Office in the death penalty section. I applied for the position. I was hired. And even though I had a sort of a surface understanding of issues related to the death penalty, it wasn't until I started to represent people that I really learned how the system just does not work. Mm-hmm. In 1996, I was offered a position at the Federal Defender's Office in Phoenix in the Capital Habeas Unit, and I worked there until 2022.
Okay.
And you mentioned the course at Sandra Day O'Connor College of Law. I've been teaching a course on the death penalty for the past 21 years.
Oh, wow. Nice. Now, what does your course cover? I mean, from start to finish, or what all do you go into?
What we do is we look at some of the significant issues related to the death penalty, and also sort of bring an Arizona focus to it when we can. We start off by reading the Furman versus Georgia case, mm-hmm. Which sort of sets the foundation for death penalty litigation and issues. And what's really interesting is that opinion was handed down in 1973. And some of the issues that the justices were discussing in their 9 separate opinions are still being discussed today, mm-hmm. and still being litigated. We take a look at the Tim Ring case, which is out of Arizona. We look at the Tyson case, and we also look at some of the issues related to the botched executions that have taken place in Arizona since 2010.
Mm-hmm. Okay, interesting. Sounds like a fascinating course.
And you're welcome to attend.
I would love to come audit, because it's there's so much to this area of law. It's hard to, as I was preparing this episode, it's hard to condense the important aspects down to one show or one episode. So there's so much that we could really delve into in mitigation, mental health, intergenerational trauma, and the standards of care that we could spend hours and hours discussing, and we do at our trainings. I'd like to give folks an overview of how kind of a case gets started. Before one of these capital cases actually begins, we've got a prosecutor's office. They have to make pretty much a high stakes decision as to whether or not a specific crime merits the death penalty or is justifiable. It's not just about guilt. Sometimes it's about the motive, the intent, the premeditation, and different aggravating factors, and as well as I would consider some public or political pressure. Could you walk us through how that decision-making process happens from a prosecutor's level when they're analyzing these cases?
Well, I want to say that the death penalty has always been about politics, and political considerations influence the decisions that prosecutors make in seeking the death penalty, and other public officials make in actually trying to carry it out. And just to be clear, not every first-degree murder case is a death penalty case. In order for the case to be a capital case, there has to be first-degree murder plus. And the plus would be aggravating factors. For instance, killing a law enforcement officer or a felony committed during the course of a murder. Those are factors that make a person death eligible. But what we have seen here in Arizona historically is that the bigger counties are more likely to seek the death penalty because they're able to afford it. Prosecuting a death penalty case is very expensive.
It is.
And then we have the rural counties that have to make a decision. Do we seek death in this case, or spend the money on some other service that the public needs?
Okay. So when you say that it's so dependent on the local jurisdiction, does that imply that the same murder that happens with the same facts in Phoenix might be treated differently than one that happens in Sierra Vista or Tucson or Shoalo?
We have seen that over the years. For instance, there was a case out of Mojave County. There were two potential capital cases, and the county attorney had to make a decision, to seek death in one case and not seek death in the other because the county did not have the resources to prosecute two capital cases.
Wow.
So I think the rural counties, the prosecutors are more likely to offer deals that are usually life or life without parole.
And it can sometimes, I feel, come across to others when we discuss these issues as somewhat clinical or insensitive, because we are talking about crimes that have risen to the level of aggravated first-degree murder, or applying these horrible aggravating factors to already terrible crimes. But these are discussions and logistical issues that someone has to make, and that we all as society have to kind of live with. When you've got a a prosecutor or a prosecuting office looking at a handful of cases, why is it, or what is it that makes them decide, if they've got the resources, to choose to seek the death penalty in one case over another? Is it a likelihood of conviction, a likelihood of a death sentence, or do you feel like it's strictly based on the facts of the crime that was committed?
It's hard to say, but the elected county prosecutor has the discretion whether to file a death penalty case, and I would say that the elected county attorney is the most powerful politician in the county, because he or she has that authority to seek life or death. Let me give an example. During the Jodi Arias case, the prosecutor sought death in that case, and the jury came back and said no death. The prosecutor sought death again, which they're entitled to do under the statute. And at the same time, the county attorney settled a case, allowed a defendant to plead who was convicted of cutting off someone's head. Now, that case had to do with a drug deal gone bad. In the Arias case, I would argue that at the most that was a second-degree murder case. So why did the county attorney at the time not pursue death not once but twice? Is it because of the publicity? Is it because of the victim? These are all questions that we don't have answers to.
Yeah, and it seems like there aren't solid answers to a lot of the questions surrounding the decision to seek the death penalty. Because in my perspective, at the end of the day, it comes down to a county attorney, or in other states, a district attorney or a federal prosecutor making a determination of whether or not they feel like this is a case that's going to result in a successful capital prosecution. And so those decisions can be somewhat subjective to the person that's making them, and the political climate, the environment in which they'll be trying the case. In Arizona, for example, we've got a lot of undocumented migrants, and that legal status issue comes up in our jury selection, in our determination of how we're going to present witnesses. And we've seen on a national level how immigration status has now woven its way into the decision as to whether or not the death penalty is sought. These capital trials are not typical first-degree murder trials. They tend to be much longer, much more costly, much more complicated. Each phase, from selecting a jury to the closing arguments, requires, in my view, careful planning, multiple attorneys, expert witnesses, and a very extensive pretrial litigation practice. Once a jury decides on a death sentence, it initiates, from my understanding, a series of appeals that can last for years or decades, usually. And this purpose is to prevent wrongful convictions and executions. Let's talk about the different stages of a capital case. Could you tell me what a typical timeline is for a capital trial compared to maybe a non-capital trial with the same facts?
I would say years for a capital trial and a year or two for a non-capital trial.
As far as the pretrial preparation?
Correct.
Okay.
And in a capital trial, there are three phases. There is the guilt phase, where the jury makes a determination of guilt or finds the person not guilty. There's an aggravation phase, where the jury makes a determination of whether the person is eligible for the death penalty. And if they make that finding, then there's a sentencing phase. where the jury gets to decide between life and death. And something somewhat unique with Arizona law, at the second phase, if the state is unable to prove aggravation beyond a reasonable doubt the first time, let's say the jury is hung, the state gets a do-over.
On the aggravation phase?
On the aggravation phase. And the same thing for the sentencing phase. If the jury is split between death and life, the state can go back and ask for death again. So there's two do-overs that are available to the state. And that's what happened in the Jodi Arias case. Right. And if a person is sentenced to death, there is the process called the direct appeal, where briefs are filed with the Arizona Supreme Court by new lawyers. The trial lawyers are out because new lawyers need to take a look at the case. And the Arizona Supreme Court reads the briefs, considers oral argument, and then makes a written decision. And that process could take anywhere from 3 to 4 years.
Now, when you say a direct appeal, what is a direct appeal, and how does that differ from any other type of appeal?
A direct appeal means that the appeal is based on the record that was developed at trial. And any appeal generally is based on the record that's developed at trial. The lawyers cannot bring in new evidence or new legal issues that were not raised at the trial phase.
Is that why, oftentimes in trials, you will hear defense attorneys and prosecutors making objections and citing federal statutes or federal constitutional protections to preserve the record? Is that for the future appeals process that the appellate attorneys are going to have to go through?
That's absolutely right. And what's critical is that if an issue is not raised either at trial or on appeal, or issues that are allowed to be raised at the next phase, state post-conviction, then those issues are forever waived. And if a lawyer later on in the process brings up that issue, the lawyer needs to show the court where that issue was previously raised and where a previous court decided that issue.
Okay. So if a trial attorney in a capital case failed to raise an objection that could have prevented evidence from entering in, and an appellate lawyer finds that problem, what recourse does the defendant have to correct the error? Can he go back and say that original trial attorney was incompetent or ineffective in some way?
There are two ways. On some issues, the question could be raised by the lawyer on the direct appeal. As to other issues, for instance, newly discovered evidence or information that the lawyer did not obtain during the investigation, those issues are raised during what's called the state post-conviction process. And that's the process that comes after the direct appeal, where the case goes back to the original trial judge. And again, new lawyers take a look at the case, develop the information and the evidence, and present it in a petition. And that process can take anywhere from 4 to 5 years as well. And what we're seeing in Maricopa County right now is that there is a shortage of lawyers who are qualified to do that state post-conviction process.
Yes, there is.
Because there are so many cases making their way through the system. It's sort of like the bulge and the python.
Right.
And right now, most of the cases in Arizona are at the post-conviction phase.
So are we seeing those from the Andy Thomas days or the Bill Montgomery days when the number of capital cases coming through the county, Maricopa County, for example, in Phoenix, was pretty high?
Yeah, that's absolutely right. Former county attorney Andrew Thomas and former county attorney Bill Montgomery sought the death penalty in more cases.
Right. Yeah, I remember those days when we were trying to staff capital defense teams and just finding qualified first and second chair attorneys. Everyone had 4, 5, 6 cases each, which might not sound like a lot if you're not handling 5 capital cases, but once you are, it's an overwhelming, some would say soul-crushing amount of work and pressure. And so now we've got a lot of cases that have come through during that time that all need competent appellate representation, plus investigation and a complete audit of the prior record. And that's creating a huge amount of workload for us in the appellate community as well.
Yes, and you mentioned Andy Thomas, and this was years ago when he was county attorney. I had one brief conversation with him in the hallway at the courthouse, and I asked him, why are you seeking death in all these cases? And his response was, well, my view is let the community decide. If it's a first-degree murder case and it fits within the criteria outlined in the statute, I'm going to seek death. Rather than exercising his discretion and being very selective about which cases to notice death in. And you may remember there was an incident where there was an aggravated vehicular homicide, and Andy Thomas floated the idea of seeking the death penalty in that case, and fortunately he did not. So he had a wide view of when to seek death.
I think that, if I remember correctly, that was a van or a truck containing some migrants being trafficked that flipped, and some folks were killed in that. If I remember correctly, I don't know if that's the same case. There's been so many of them,
and that may be one, but the one that I'm thinking of, again, I'm going back. I think it may have been a drunk driver or someone who was exceeding the speed limit, by a lot.
And there's been some arguments made, and I know that there was a case that went up to the U.S. Supreme Court, the Hidalgo case, where the argument was that the Arizona definition of a capital qualified case, or the aggravators that could apply, was too broad, and that they could be argued to include the great majority of homicides instead of just the worst of the worst. Could you tell us kind of what happened with that litigation and what the argument was and how it resulted?
Well, first, I think Susan Corey and her team did a great amount of research and did an excellent job putting that case together. I think one of the reasons the U.S. Supreme Court passed on it is Justice Breyer, if you remember, issued a statement from the denial of certiorari in that case. And I think he was concerned about the quality of the data. Whenever cases go to the Supreme Court and they're looking at data, it needs to be very robust. And look at the McCleskey case, where David Baldus did a study of race and the death penalty. And the majority in that case had some problems with the data. So I think Justice Breyer was sending a message, come back when the data is more robust.
Okay.
But to that point, I think what Susan and her team did was prove the point, and that is, any case that's a first-degree murder case is eligible for the death penalty, and we saw that with Andy Thomas, and to a lesser extent, Bill Montgomery.
I agree. The levels of appeal that death penalty cases get, you mentioned the direct appeal and state post-conviction relief. So the direct appeal examines the record in the trial. The post-conviction relief phase, could you explain what that goes into?
That's the phase of the proceedings where a new legal team reviews the entire record, the trial record, and the direct appeal, and they reinvestigate the case. They may bring on other experts. What we have seen, because these cases go on so long, is that sometimes the science develops, and there are issues that are now ripe based on the developed science. Also, maybe the trial lawyer was ineffective in their representation. Maybe they did not interview family members, school teachers, and others who were able to document what happened to the client as he was growing up, and new information is developed, and that is presented to the post-conviction court to say, look, this lawyer missed some issues, and had these issues been raised at trial, there's a reasonable probability that at least one juror would have come back with a recommendation less than death.
That makes sense. As I was coming over to the studio this morning, I was thinking of my first capital trial. And, in totality, this was the first capital case that I had ever taken on. It was 12, 15 years ago. And in totality, I think I spent 700 hours working that case from start to finish through trial. And I came away from the trial thinking, boy, I worked too hard on this, or I spent too much time and didn't get what, my work wasn't used to that extent in the trial. So I was very disheartened. I'd spent too much time on issues that weren't eventually useful. And then during that time, I got connected with an appellate attorney named Julie Hall, who I'm sure you know very well.
Yes.
And Julie had us work a post-conviction case. And the last I checked, we were over 6,000 hours on that one, because Julie is what I would consider a scorched earth litigator. And if there's any witness that has seen or interacted with our client at any point in life, they want them found, interviewed, declaration signed, and the level of thoroughness really increased when I started working post-conviction, because I was exposed to lawyers that would dig into every single issue. And that, in my view, has helped our trial practice, because we can try and head those off at a trial level. And we've expanded what we do in the initial stage to hopefully catch or as many of the issues as we possibly can before a case goes to trial. I've noticed that when we've discussed this in the past, just in the community, there's a lot of pushback on the appeals process, generally from the public. They look at the process and the appellate issues that we're raising, and they want to streamline the appellate process for death penalty cases. Could you explain why, or if that's flawed thinking, and what the flaws in that strategy would be?
Sure. And before I do that, you said 700 hours and 6,000 hours. I had a case years ago where the defense investigator put in 13 hours on the case, and 1 hour was waiting at the county motor pool for a county vehicle. But what people need to understand is that people who are sentenced to death do not get extra appeals. They get the same due process that anyone who is convicted of a crime and sentenced is entitled to. But what happens is that if someone gets a life sentence, or someone is convicted and sentenced for robbery or burglary, they may file one appeal. The issues will be very narrow. And then they decide, I'm not going to pursue this anymore. But in a capital case, if we're going to execute our citizens, we need to make sure that the process worked as best it could. Most of the people sentenced to death want to pursue all of their appeals. Because you may be looking at a trial that lasted 6 months, the record in that case is going to be big. And the appellate lawyer has to review that before he or she writes and files the brief. And then the post-conviction lawyer needs to look at all of that as well. So as the case moves through the system, the record becomes more voluminous and it takes more time. And finally, it's important that every possible issue be raised, whether it's in post-conviction or the direct appeal, because if an issue is not raised, then it's waived, and the person can never bring it up, say when the case gets to federal court.
Okay. Now, and that brings me to the next question, because the majority of my agency's work has been in state-level trials, state-level post-conviction relief, and federal trial-level preparation. And we've got a couple of different cases now that are coming through the federal habeas units around the country that are looking at the state application of federal law. Could you explain what the federal courts are doing in these state level cases? If I've got a guy, for example, that's sentenced in Maricopa County of first-degree murder, he's given the death penalty, why does this case then go into federal court, and what are they deciding there?
Under federal law, a state prisoner is entitled to ask the federal courts to review the conviction and sentence to determine whether or not a federal constitutional violation has occurred. What goes on during the state proceedings focuses primarily on state law issues and the state constitution, although those federal constitutional issues need to be raised during the state proceedings so that when the case finally gets to federal court, the federal courts can review those issues. And again, the federal habeas process is somewhat the end of the line in a death penalty case, and you have new lawyers looking at the state post-conviction proceedings, the direct appeal proceedings, and the trial proceedings, and trying to synthesize those issues and put together a petition for the federal court to make a determination of whether there was a federal constitutional violation.
Okay. And I've noticed that when I've now been getting requests for investigative services from some of these capital habeas units, the level of detail and molecular analysis that they are doing is something I was not used to on the state level. Determining a slight variation in a cause of death, or a simple phrasing of a jury instruction, and it's seems to be the amount of litigation that goes in on the federal level is a lot more granular. Is that accurate? Is that the goal of the habeas unit, to look at a lot more specific detail than is addressed on the lower levels?
What the federal lawyers are looking at is whether, for instance, the state post-conviction lawyers missed something, and to your point about the phrasing of a jury instruction, or the presentation of mitigating evidence maybe not being as developed as it should have been. Those are all very important to try and convince the federal court that these issues are serious, and that the matter needs to go back to state court for those issues to be resolved by the federal court.
Okay. So it sounds like what we have here is somewhat of a separation of powers, or a checks and balances in the legal system, similar to what we have in our ideally in our state and federal governments. We should have various checks and balances on the different branches. Is that something applicable to this process?
Yes, with this caveat though. In 1996, Congress passed the Anti-Terrorism and Effective Death Penalty Act. And part of what Congress did through that legislation is limit the ability of the federal courts to look at the issues that were presented in state court. So, for instance, in the 1970s and 1980s, people sentenced to death were getting relief in the federal courts in 60% of the cases, because federal courts were able to have a more expansive review of the conviction and sentence. But with the passage of the 1996 legislation, and because the federal courts are really constrained and limited as to what they could look at, the review granted by federal courts is in the single digits.
Oh, wow.
And if a federal district court or federal circuit court should grant relief, given the makeup of the Supreme Court right now, that is usually taken away. It's very rare today for a person sentenced to death to get relief in the federal courts.
Seems like we're going somewhat in the wrong direction. If we've got less opportunity for oversight, and if a country is going to be executing its citizens, do you feel that we're gaining protections, or that we're losing them?
Oh, without a doubt, we're losing protections because I can't tell you how many times federal judges have said, but for the Anti-Terrorism and Effective Death Penalty Act, I would have given relief. We had a case like that out of Arizona a couple of years ago, the Dickens case. I think it was 2012. And it was a 6-5 decision by the Ninth Circuit. And the judge in the middle basically said, this person is entitled to relief, but I can't vote for relief because I'm limited by the Anti-Terrorism and Effective Death Penalty Act. So we're taking away protections. And, if a case is not successful at the trial level, and I think that's why there are so many resources now being put in to cases at the trial level, the chances of getting relief are diminished as the case moves forward.
Wow. And that's one of our big arguments for resources at the trial level, because we know that your investment in a defense strategy or a defense position is much more effective on the trial level than it is in the appellate level. It's much better to have the information and use that for negotiations before you have a conviction, rather than trying to unring the bell, later down the road when you're in appellate court.
It's interesting that you bring that up. There was a recent ABC 15 ProPublica investigation that reviewed 350 death penalty cases in Maricopa County between 2004 and 2023. And since 2007, Maricopa County has spent $289 million for capital cases, and that's just for the cost of defense. So to your point, the resources are being put into the cases at the trial level. But what's also interesting is that out of the 350 cases that were reviewed during that 20-year period, only 13% ended up with a death sentence. So I would argue that the county attorneys have not been very good in sorting these cases out before seeking the death notice.
What do you think would be a solution to that? I mean, there's a time limit where the county attorney has to make a determination as to whether or not they're going to seek the death penalty. Do you think that time limit is appropriate, or should it be changed to give a more comprehensive review of a case before a decision is made?
My understanding is that there's sort of an understanding between the county attorney and the defense bar that if additional time is needed, that the defense could request it, because what the defense is doing early on in the process is trying to collect information, evidence, expert reports to convince the county attorney not to seek death. But what we have seen is that because these cases take so long and it takes a while to develop this mitigating evidence, sometimes years, the county attorney is in a position where she's making a decision 5 years in not to seek death.
Well, and you raise an interesting point, because in that first, was it 90 or 180 days? The first time limit for us to present our request to the county attorney for them to not seek the death penalty, what we've been seeing in the last handful of years is that prosecuting investigators are going out. I've seen them as soon as 12 hours after a homicide and doing interviews to prevent or get ahead of our request for them to not seek the death penalty. So oftentimes you have investigators from the county attorney's office or from the police departments out doing interviews because they're trying to build up the aggravating factors, Or I would say that they would probably argue that they're determining whether or not there's mitigating evidence or not. But I think the reality is that they are looking to get ahead of mitigation investigators and defense investigators from collecting that information. So to me, it looks like they are making the decision or the determination to go down the path towards a death sentence pretty quickly after a crime is committed.
Yeah, and I think that has changed over time. To your point, this is sort of a recent occurrence where the investigators from the prosecutor's office or law enforcement are going out and doing this. It presents a problem for the defense investigators because they may go out a couple weeks later to talk to these same people, and by that point, maybe they've made statements. Maybe they refuse to talk to the defense investigators because they said, "Oh, I already talked to the police about this, and they said they're going to present this information." So, in my view, I think it would be better if the county attorney did not take this approach to the cases. But that's a decision that she has made, and the defense is going to have to try and work through that.
And we have. I had a case that we were asked to take on recently, and by the time, this was the guy had not had his initial appearance yet. He was still in the hospital after the crime had occurred, and so he hadn't been charged, but the prosecutors and their investigators were already out knocking doors, trying to track down family members, and finding. Now, luckily, the lead counsel and I had been assigned to the case early on, and had made a point to get out and contact all of the family right away to let them know what was potentially coming. But had we not had those conversations within the first day, they could have easily thwarted a lot of efforts by being tricked into thinking that they're helping out their family member when in fact they're not. They're doing the opposite.
And to that point, that's why it's so important as soon as the defense lawyer is appointed to the case, that he or she starts putting together a team. And obviously one of the first people that you need to talk to is your client,
right?
But also going out and talking to the client's family, because they're going through a sense of loss as well. A family member is in custody. I'm sure there may be some confusion and shock, and it's important for the defense team to contact family as quickly as possible.
Dale, I want to go into a bit of a technical and somewhat political area here. And, honestly, on this show, we've tried to stay as apolitical as possible because I feel that, justice should be blind and regardless of who's in power, the wheels of justice should turn the same. In December of 24, former President Biden commuted the sentences of 37 men on federal death row in Terre Haute. And I remember before this happened, there were emails going around in the defense community, and many were looking at how to reach out to the Biden administration to ask him to commute these sentences because there was a fear, sounded like there was a fear that the incoming administration would speed up the process and execute federal inmates while their cases still had a lot of claims to pursue. Could you explain what this move from President Biden did? Like, what was the net effect of that order that he made? Thanks for joining us today. This was part 1 of a 2-part series on the death penalty. Come back in 2 weeks to hear the rest of this conversation with Mr. Dale Baich and understand the death penalty in its totality. Thank you for tuning in to Truth Be Found. The hunt for answers never stops, and neither do we. Don't forget to subscribe and follow us online to stay in the loop. Remember, truth has a way of coming to light. Until next time, keep your head up and your eyes sharp.